SJC-11561, Barron Chiropractic and Rehabilitation, PC, v. Norfolk and Dedham Group.
Your Honor.
If you'll hold on just one moment, sir. Okay, let's proceed. Yes.
Thank you. Your Honor, Frank Amar for the plaintiff appellant Barron Chiropractic. This case started as a fairly routine 34M case. The principal issues were the necessity of post-physical exam or post-quote IME treatment, totaling roughly $1,500, and the necessity of bills or the reasonableness of medical bills which the insurer failed to pay prior to the IME, which totaled about $60. The case was filed in November of 2009, proceeded in a very ordinary course. Discovery was exchanged. We had a pretrial conference in May of 10. Trial was scheduled for August. Counsel asked, my opponent asked for a continuance. I assented. The court rescheduled it to October of 2010. 6 days before trial, the defendant sent a check for the full amount of the PIP benefit sought, $1,544.06, and claiming, and moved for summary judgment thereafter, claiming that, well, Barron's no longer an unpaid party under Chapter 90, Section 34M, and therefore we are entitled to judgment. However, we sent the check back shortly after we got it with a letter saying we're rejecting the settlement offer.
How do you get around Facione on this case?
Well, actually, in many ways. The facts of Facione bear no resemblance to what we have here. Facione was an uncontested claim. This one was hotly contested before the litigation. After
But it wasn't paid. The key thing was the claim was not paid. The PIP claim was not paid. The individual was required essentially to file an action,
Right.
and then it was paid.
Immediately. I mean, in the Facione case.
After a lawsuit was filed.
Right. And I think the defining difference was in Facione, the plaintiff accepted the payment.
Well,
And in this case, it was rejected. The Facione case has been implicitly overruled, whatever limited application it had, by Bohm versus Premier Insurance Company, a 2005 case. In the Bohm case, the SJC, in deciding whether jury rights attached to these 34M cases, said there's nothing in 34M that distinguishes this case from the ordinary contract action.
But Bohm is an appellate division case. Are you
No,
saying?
Bohm is an SJC case. 446 Mass.
OEHM?
BOEHM. Yes, it's at 446 Mass. 689, 2006.
Okay.
and you say that undercuts Facione
Yes.
on this very specific point?
No, but impliedly. The Bohm case said that the Facione case essentially said, well, look, you know, you're looking at a statute. If the statute doesn't say it doesn't apply. In the Bohm case, however, the SJC said these are ordinary contract actions.
In Facione, we said that 34M means any amount due and payable refers only to PIP benefits due under the insurance policy.
Right.
And that were not paid in full.
Right, but the
that's what it means.
plaintiff in Facione accepted the payment and proceeded under I was counsel in that case, proceeded under the theory that the recovery of interest on the unpaid benefits would trigger the attorney's fees provision of 34M. And in Facione, the court said, no, this is the essence of Facione. The court said, no, a recovery of interest does not trigger an attorney's fee award under the statute, only an amount due and payable
Well, yeah,
PIP
judgment,
benefits.
I mean,
Facion stands for the proposition you need a judgment, don't
A
you think?
judgment, yes, you need a judgment. Now, the position taken by my opponent in the appellate division is that the statute can be easily undercut at any time during the litigation by the insurer simply by paying after suit, and in this case, a few days before trial, what it was obliged to pay before suit.
But we said in Facione, the remedy there is 176D or 93A.
Well, yes,
If in fact it's been a willful, intentional failure on the part of the company.
well, yes, but in Facione, the plaintiff did not have any damages, couldn't recover PIP benefits in that case because when she got the check, she cashed it and accepted the payment. And under the case law, you can validate, a plaintiff can validate a insufficient tender by simply accepting it after litigation, and that's Davis versus Continental, Hamlin versus Red Nola, the Castle case.
So your view is that if an insurer pays the full amount of the PIP, and if you refuse to cash the check, you can proceed to trial and get your attorney's fees?
That's my position, and that's also the position of the Northern Division, Appellate Division, in several cases, which I cited early in my argument.
Is there a time at which you're obliged to accept it? I mean, if they pay you earlier, can you still say no?
Yes, you can. In other words, the term unpaid party refers specifically in 34M to a person, or is defined in 34M as a person whose benefits have remained unpaid for more than 30 days. The way the Appellate Division read it, and my opponent argues it, is that an unpaid party doesn't mean that. It means the status of the party before judgment. But
Well, you don't even, I mean, the portion of 34M that talks about attorney's fees links it to a judgment.
a judgment, yes. But the legislature could not possibly have intended that whether a plaintiff can successfully get a judgment be in the very palm of the insurer against whom the statute was aimed.
So you're saying if, like, day 32, you can refuse to accept a tendered check? And
No,
you
no.
still have a 93A action?
Well, if we're talking in the context pre-litigation or post-litigation.
Well, then what does it have to do with 30 days?
The legislature said in 34M that any time a person is unpaid for more than 30 days, he may commence an action in the district court under Chapter 90, Section 34M.
So post 30 days, whether it's pre-litigation or post-litigation, I don't understand what difference that would make as to whether or not you have an obligation to accept a tender.
As a practical purpose, benefits.
It's practical, but I'm not talking practical. I'm talking about,
Well, under Massachusetts, no one would do it, but under Massachusetts common law, and I cited Levin versus Wall, but there's dozens of cases before it, a party has no duty to accept another party's performance once the date for performance is passed.
and that would be any time after the 30 days.
Right.
Yeah,
I mean, we're talking theoretically. I mean, I've been practicing this area of law for 20 some odd years, and I've handled thousands and thousands of these cases, and I've never seen a provider send me a case where he got paid 33, 32 days after and says, I don't want to accept full payment. I mean, yes, on a theoretical basis, Massachusetts common law says you still have your right of action.
But, I mean, isn't your remedy here in terms of the practice of the insurance industry not to pay until you're forced to bring suit? Isn't your remedy a 93A? It's not under 34M. Isn't it really a 93A? Or, well, I guess you can't bring a 176D action yourself, but
Well, yeah,
at
I
least
mean,
a 93A?
Yeah, there's a 93A remedy, but the 93A remedy goes to the practice. The 34M remedy goes to the contract. I mean, and there's a difference, obviously, in a contract action, you don't have to prove bad faith.
But one way of reading Fascion, I think, or the footnote in it, and I don't know remember the number, but is that the reference that you make to, what's the contract tender payment, what's the statutory?
232A?
232A. It seems to me implicitly, the court implicitly rejects that applies to the 34M.
Right. But it's, yeah, I hear you, and I mean, that's good news and bad news. The good news is,
Well, how do you read it?
well, okay, let's play devil's advocate and say, yes, 232A doesn't apply. Well, then we have the 2006 Boehm case that says these are ordinary contract actions, okay? And in an ordinary contract action, under the common law of Massachusetts, going right back to Lord Mansfield, all right, a tender after the date for performance need not be accepted, and there can be no tender in a legal sense after that date. So if you ask me, and you are, I would say, yeah, go along with that. 232A doesn't apply. And if we can't look in a vacuum, we have to look at the learning of the judges, you know, for the past 200 years.
But okay, we can't, though, I think, take this out of context, which was 34M was really trying to, I think as the Fascion case goes through, limit the amount of litigation and try to cut the costs of auto insurance and all these things. So in having purely for 34M purposes a sort of clean rule that if you pay before the judgment, that's okay, leaving parties to 93A, or if you're the individual, 176D, for bad behavior on the part of the insurer.
Well, the problem is that most of these cases, okay, and I'm talking the very large percentage of them, there isn't going to be a 93A action that has any vitality. There's there's a joke, perhaps like it emanated from the SJC itself, is that what's the difference between a criminal case and a civil case in Massachusetts?
You think we emanate jokes?
Well, the difference is the criminal case has no 93A count, okay? So,
Joke? Sorry.
and as a matter of fact, in the Fascion case, Judge Spina said to me, and I'm burdened with what they call a photographic memory, why didn't you file a 93A count? And I said, well, this is a simple contract case, and, you know, I didn't want to make a big deal out of it. He said, well, everyone else does. And the only reason that 93A is a significant component of these cases is because of this rule or misconstrued rule in Fascion. Now, part of the, one of the legislative purposes of no fault was to relieve congestion in the courts. Okay, we all have to agree, and I mean, and you sit on these all the time, including today, is that 93A litigation is far, far more complicated and more time-consuming for the parties. Therefore, insurers have to pay more to defend them. More time-consuming for the courts, motions for summary judgment, inevitable appeals, and shifting 34M liability for attorney's fees onto 93A soundly defeats that purpose. And you have to ask yourself the question, well, if the legislature intended for 93A to be the remedy, well, why did it enact an attorney's fee provision in 34M at all?
So pragmatically, I'm just trying to play this out. Pragmatically, if you prevail, when you file suit, you seek the money from the insurer pays you too little, you file suit, they come and they say, okay, we'll pay up. You refuse. They could tell you, we are going to request an agreement for judgment, and then you would get your attorney's fees up to that point.
Right. And that's the way, I mean, that's the ideal, actually. And in the normal course, These cases are resolved before defense counsel even gets involved. I mean, we do have to litigate some, but,
If that's the case, then there would be no attorney's fees, or very few attorney's fees, just the amount involved in the complaint.
You agree on an attorney's fee in addition to the damages that are involved, plus you have the costs of suit, and that's, that's not insignificant in these cases. We have $250 here in costs relative to a $1,500 outstanding debt. So the way Your Honor suggested is precisely how this should be done under the law and under, under all reasonable constructions. And I want to leave you with the point that 34M is a remedial statute by its very language and under the case law. And as a remedial statute, it has to be construed in a manner which advances the remedy. I mean, that's a very basic rule of construction. And all of the cases, and I mean all of them, and I've listed several of them at page 21, starting with the Malo case.
Counsel, I'm very sorry, but your time is up. Thank you.
Thank you.
Good morning, Chief Justice and Justices. Joseph Cholo for the defendant, Norfolk and Dedham Group. I'm joined today by my co-counsel, Attorney Michael Snyder. If I could touch upon Justice Botsford's point about the tender statute for a moment. In the Fascione case in 2001, this court raised that as a footnote, this footnote number 1, and said that it does not apply. I think that this case may provide this honorable court with a chance to raise that analysis beyond a footnote and develop it further. The tender statute was enacted in 1831. It's a general statute that applies to claims brought in contract. Certainly, in 1831, the legislature could not have been contemplating automobiles, never mind automobile insurance. But fast forward 139 years later, when the PIP statute is enacted in 1970, this court in Fascione recognized that that the PIP statute as a new right becomes an exclusive remedy. My point in bringing up the tender statute is that in 1970, the legislature is held to know that the tender statute exists, and they could have incorporated components of the tender statute.
But he doesn't seem to be relying as much on the tender statute, at least at argument, as he does about the fact that in the Bohm case, he says that we've held that this is just an ordinary contract, and as such, we have common law matters relating to when tender occurs and may not occur. So you don't even need the statute.
As to the Bohm case, Your Honor, in 2006, I would suggest that the ordinary contract action component of that argument was in the context of whether or not there is a jury trial. And in Bohm, this court said that in statutes where there has not been a right to a jury trial, the legislature has expressly said that there is no right to a jury trial, which is not present in the PIP statute in Chapter 90, Section 34M.
What do you say, though, to the argument that I think the policy argument underneath the plaintiff's position here, which is it actually does save costs and makes for a more efficient system if the insurer is not permitted to do what you did here, that is, require the provider to file suit, wait until 6 days before trial, and then say, here you are. No judgment, no attorney's fees, no costs. That it actually helps because you would have an incentive to pay sooner.
Well, in that case, Your Honor, we could take it even a step further and say that where claims are disputed, where an insurer finds that certain benefits claimed are unreasonable and unnecessary, that whenever it may cost more to fight it than pay it, that they're going to pay it 100% of the time. And insurers have duties to their policyholders, and they're bound under the PIP statute, under the car regulations, to pay only those claims that are reasonable and necessary. So there may be some instances where the costs of fighting a claim are certainly more than it would be just to pay it off the bat. And in this case, that became
Ultimately became
ultimately the issue on August 10th, 2010, when Norfolk learned for the first time that its expert fees for Dr. Kevin Morgan would be a minimum of $2,500. And they thought about paying it. thought about not paying it. And about 45 or so days later, they ultimately said, we'll just pay the claim and extinguish the PIP claim.
I guess what maybe Justice Bonsford was asking this, but let me ask it. Have we just decided Fascione wrong?
No,
Just reverse course on that case?
no, Fascione was correctly decided, Your Honor, because it was rooted in the plain and unambiguous language of the PIP statute, which says only upon a judgment for benefits due and payable can there be any further remedy under the PIP statute. If that result is somehow distasteful to plaintiffs in these cases, and it seems that it is, their remedy is to go to the legislature. And I'll note that on January 2nd of 2009, then Representative Eugene O'Flaherty submitted a bill to the legislature to amend the PIP statute, and I was at the State House Library on Friday to confirm this. That bill died in a committee in 2010. There's been no activity on that bill since then.
Amended in what respect? To change Fascione?
To change it in a way that the plaintiffs would, I think, find it to be more friendly to them, to still allow for attorney's fees.
Even if you hadn't gotten a judgment?
Even without a judgment, and even when it's paid after the commencement of litigation. So I'd suggest that we might infer from 4+ years of legislative inaction on that proposed amendment that it doesn't seem to be something that the legislature is willing to do. And I'll also note that the bill was refiled by a second legislator in 2011, and again it died in committee in 2012 with no activity on it since that time.
Why should the plaintiff have deposited a check which says a full and final settlement?
That argument was certainly made, Justice Gantz, at the trial court level and again at the appellate division. And regardless of the language that appears on the check stub, it was accompanied by a letter from counsel saying, here's the $1,500 in change and a stipulation of dismissal as to your PIP claim. Norfolk and Dedham never suggested or wrote in that letter that they're expecting this to extinguish the litigation in full. The letter from counsel dated September 28, 2010 clearly said, here's the check, and it cited the Fascione case and said, here's the stipulation of dismissal as to the PIP claim only. Norfolk and Dedham was willing to go forward.
Was that, at that time, I can't remember this, had the 93A piece of this, was that part of the original complaint?
It was always part of the original complaint, yes, Your Honor. But I'd say
And you
just,
were granted some, go ahead, I'm sorry, finish.
just very quickly to finish the response to Justice Gantz. The appellate division looked at this issue and said, regardless of the fact that the check said full and final settlement, that looking at the totality of the circumstances, particularly the letter that came from counsel explaining what the payment is for, that gave a fair reading of what the payment was for, that it wasn't a settlement offer, there's no conditions attached to it.
So, so your view is that there's an obligation to accept. Once you pay, they have to accept.
I would say, Your Honor, as a matter of that being their client's money, that there might be, and then again, I don't know what discussions took place between plaintiff and plaintiff's counsel, but maybe there's an obligation to accept, but they reject it at their peril, I think, because now they risk having judgment against them per the PIP statute in the Fascione case, and they don't have the money either.
Right, well, that's always the risk they take when they say no, but there are a number of cases in which there are attorney's fees, and can't a defendant say, I reject this because the settlement does not include the attorney's fees, and I want to proceed to trial and prevail there and get the attorney's fees that have been incurred?
Well, then we run into the language, the clear language of the PIP statute that says if there are no, I'm paraphrasing, if there are no PIP benefits that are due and payable, that there can be no judgment. So once it's been paid, whether they cash it or not. In fact, in 2008, in a case of Essex Chiropractic versus Plymouth Rock, the late Justice Brandt said that would be an absurd result for the plaintiff to simply reject the check. That was echoed by Justice Merrick, Judge Merrick in this case, saying that he could not improve upon that characterization of it. And certainly we wouldn't be so arrogant to think that we could improve upon it.
But your brother was saying that your check came more than 30 days after it should have been paid under the statute. And as I understand his argument, he's saying that if you want to settle, if the insurance company wants to settle the case, they can pay the full amount that's due plus attorney's fees up to that point in time, plus the court costs of $250. If they don't do that, then both parties run the risk of something that may or may not take place as a result of a final litigation. If the plaintiff wins, you can end up paying more attorney's fees. If the defendant or if the defendant wins, you wouldn't have to pay anything. But that's the risk that you always run.
But under the PIP statute, it was clear that the claim was extinguished. Insofar as there's a continuing dispute about whether it was proper or improper to pay it more than 30 days later, the Fascione case says that the 93A statute is the remedy for that claim.
And on the 93, and is that before us? Because you won summary judgment on the 93A claim as well.
It is, Your Honor. The notable thing about the 93A claim is that at the summary judgment stage, the plaintiff willfully refused to submit any countervailing factual materials. They state in their opposition brief that they filed that because of Norfolk and Dedham's evidence that they don't bear the burden to rebut it. And I would suggest that was a fatal tactical decision. If it was any tactical decision, it was a fatal decision because it might allow this court to not even have to reach the substantive analysis of the 93A claim in this case. Certainly we say that on the merits that we succeed on the 93A claim anyway, but their decision to not produce any countervailing materials on the 93A claim was fatal. In fact, it also ignored the body of case law that says that a trial court can accept unrebutted facts. So whether or not they chose to rebut it, the trial court certainly had discretion to accept Norfolk and Dedham's well-reasoned affidavit that explained why they made the payment, when they did, and what reasons it had prior to litigation for not paying the claim.
I understand that the Barron didn't contest it, but how at the summary judgment level could a party, I mean, your client made the decision and it can say what it will about why it did, and what would, if Barron had wanted to dispute the affidavit, how does it do it? It's not control of these facts.
It doesn't have control of Norfolk and Dedham's facts.
Right.
That's absolutely true. But they chose to put this matter in the civil session as opposed to small claims. There was an opportunity to do discovery, to develop the defenses that they put in their complaint. In this case, that's 93A.
There was no depositions in this case?
There was no depositions. There was never any leave requested to take depositions either.
I'm sorry, there was no.
There was never leave requested since the amount was under $5,000. But certainly they could have developed these facts through discovery, Your Honor. And moreover, if they felt at the summary judgment stage that they needed somehow more time,
56F.
they could have invoked Rule 56F to say that we need more time to take a deposition so that we can assert our defense. But not only did they not avail themselves of that remedy under Rule 56F, but they said we don't even have to oppose the facts that are set forth by Norfolk on the 93A claim.
But isn't there a concern? Well, I have a concern. We have fee-shifting statutes for a purpose. They're designed to encourage individuals to be able to retain attorneys for the purpose of enforcing their rights, with the promise that it's worth the while of the attorney to do it, even when there may not be a lot of money at stake, because if you win, you'll get your attorney's fees. The insurance companies can essentially negate that by essentially saying, we're going to make it unprofitable for any attorney to take these cases because we're going to wait until the eve of trial, and then if we think we're going to lose, we pay up. And therefore, attorneys are not going to want to invest the time and effort to prepare for trial because it's going to turn out to be a money loser for them. Why should we let the insurance companies, essentially negate the legislative intent in providing it as a fee-shifting statute?
Well, under 93A, Your Honor, certainly the remedy was there if they felt the payment was unfair, deceptive, or delayed by several months.
What would they get? They would get the interest.
No, they'd get their attorney's fees.
They could get attorney's fees under Chapter 93A.
Attorney's fees on the 93A.
But one part of your question indicated that if they feel that they're going to lose, that was part of the hypothetical. In this case, with Norfolk and Dedham, up until they made the payment through today, they still stood by their good faith reasons for denying the claim. It was never reasonably clear that they owed the benefits at all.
But I mean, it's a little, I'm not impressed by the idea that you were shocked to learn what the medical person was going to charge, given that you do these cases all the time. So you had to know that you're going to need to have a medical expert, and you had to know that the cost of that was going to be greater than the amount at issue. So
And that was
this
the
idea
plaintiff's
that we're
burden.
stunned to learn how expensive these are seems a little bit like Casablanca.
That was the plaintiff's burden at summary judgment, I would submit, Your Honor, to demonstrate that Norfolk and Dedham knew or should have known before that unrebutted date of August 10, 2010, as to what the expert fee was going to be.
You mean summary judgment on the 93A?
As to the 93A claim, because they're claiming that Norfolk's reason was essentially a pretext for some other improper motivation, when in fact they submitted no facts whatsoever at the trial court level to suggest otherwise. But as to the point that Your Honor made about delayed payments and the fee-shifting statutes, the Norfolk and Dedham relied upon the IME that was conducted by Dr. Morgan, as well as the fee review, and plaintiff never submitted anything to demonstrate.
Right, I'm not saying that you acted, I'm not saying that they would have prevailed in the 93A. I'm just troubled by a practice that essentially says we're going to not decide what to do until the eve of trial, where the attorney has incurred fees, and essentially means that attorneys can't realistically do this because they're not going to get any money for it.
It may have been a different result if they had not that fact of learning what the expert's fees are, because in this case, the landscape of litigation shifted at that point. Had they...
But you had to know that the cost of litigation was going to exceed the value for long ago. I mean, that couldn't have been news. You couldn't have litigated this case for $1,000.
Well, for a $1,500 claim, when they learned that it's $2,500 at a minimum for 1 day of trial, for Norfolk, they indicated in their affidavit that was a significant difference to them, which made them issue the payment.
I mean, I guess the concern I have is we have a lot of fee-shifting statutes, including in housing court and others. And if the message is that you can always negate the ability of the attorney to get their fees because they have an obligation to accept a payment that does not include attorney's fees, it's going to make it awful tough for these attorneys to have a reason to defend these cases. I'm sorry, to prosecute these cases.
And they'll still have 93A as a remedy.
Counsel, we have to leave it there.
Thank you, Your
very
Honor.
much.